Yeah, hello again. After a relative long break, here's again some comment on German tax rules, Foreign Relations Tax Act, and other things related to cross-border tax saving opportunities. And the chapter we have to talk about now is chapter 3.4, the optional unlimited tax liability under paragraph 1.3 EStG, and I may add that paragraph 1a EStG as an additional rule, which adds some aspect to that. Well, where are we now? The overall question is personal tax liability and tax saving opportunities, either the opportunities officially wanted or the ones which are not so well liked by the fiscal administration. And now we come to a chapter or subchapter which is well established in the law. Here the legislator really wants to grant you certain choices, and that's the optional unlimited tax liability, which exists since the middle of the 1990s. Well, what is it all about? Under limited tax liability, a taxpayer can usually not deduct special personal expenses. Special expenses. The reason for this is the idea that usually the state of residence will take into account the personal allowances. And so the idea is, if you can get all these tax advantages at home, then if the state of your limited tax liability also grants you deductibility of personal allowances, like the basic allowances, the splitting tariff procedure, children's allowances, and all that, that would bring along the risk that one and the same taxpayer could deduct the same amounts twice in two countries, in the state of residence and in the inland. So the idea was, everybody has a state of residence, so probably every state of residence grants the deductibility of these personal allowances. So the state of source of the income does not need to grant that deductibility. And that naturally was the idea. Now, a brave and simple idea can very often, if you apply it to reality, lead to drastic consequences which were not foreseen. For example, in real life, our simple model, you can always set off your deductible private expenses in the state of residence as an international tax system that could work as follows. Let's first look to the situation of somebody living in the inland. We have a taxpayer who has a job, 60,000 euro. Now, by the way, this is probably a bit optimistic, but the first advantage of believing in a salary of 60,000 euro is this slide can still be used in 20 years. And the other thing, it's so great a salary, one should also be able to dream a bit about the future. Well, our taxpayer now is married, so he or she wants joint assessment and would get it. So we would have not only one basic allowance, but the second one too, for reasons of simplification, not for conservatism, but only for reasons of simplification. We just assume the second spouse does not work and has no own income, because then the effects of what might happen will show up far more drastically and clearly than if we complicate the example by a second income of the second spouse. So we have two basic allowances. Now let's really run our fantasies wild and say the two have 10 children, because then our taxpayer has 10 children's allowances. That is approximately per child 5,000. So we have already a deductible amount of 50,000. Now you see we already have done enough, because now the contributions to state health insurance system would not really matter. Let's say that could be another 10,000 deductible. Would be great. The state-run pension system also forces you to make contributions. Usually they are deductible special expenses. Well, the amount here does no longer play a role. We are already arrived at zero, but it would play a role under normal circumstances. For example, if our taxpayer had only 2 children. So there would be a mass of deductible expenses. If that is not yet sufficient, then let's assume the 10 children come from 3 former marriages. So we have 3 divorced spouses which claim financial support from our taxpayers. So also that could be deducted from the taxable income in an inland case, so we can safely and proudly say the total taxable income of that taxpayer will be according to or due to personal allowances in the end a zero. By the way, that's entirely justified because if somebody has 60,000 and all these personal problems here, then that person is not rich, that person is poor. Huh? The money coming in is not sufficient to cover all the necessary expenses to survive, so this is not a rich taxpayer. This is probably somebody on the verge of poverty. So the result is absolutely correct. Also, under the social aspect, this person has a zero tax to pay. Congratulations. Hope you bring up your children well and hope you treat your spouses well. And so everything's fine. Now, let's imagine what we have if the taxpayer lives abroad. Same situation, but now taxpayer, let's say, lives in Belgium and comes in, commutes to the workplace every day. Income from a job is again 60,000. Now married, yeah, but no splitting tariff granted in Germany. The idea is there will be some social privileges or there will be some deductible positions which are financially equivalent to the advantages from the German splitting tariff in your home state. So granting you the splitting tariff in Germany, in addition to the financial advantages which you can obtain by your marriage status in your residence state, that would be regarded by a fiscal officer as a kind of fiscal bigamy. You can't be married once and collect the financial advantages twice. That's immoral, so clearly not. Now you have the 10 children and you want to claim the children's allowances, and surprise, that would probably not be granted in the state where you earn your income. The underlying idea is, well, you can probably deduct that in your home state. Here, I'm not sure if I can guarantee that this was really always done this way in Germany, but at least I wanted to present the case in a very simplified way. And if we really apply that principle, no personal allowances in the state where you do not live, then that would have been the consequence. So no deductibility. Contributions to state health insurance. Well, you will be able to claim a personal allowance in the state of residence. So nothing here. State-run pension system, nothing here. There will be something like that in your state of residence. We must avoid double deductibility. The financial support to all the 3 divorced spouses. No, that will be expected to be done by the state of residence and so on. And by the way, if the state of residence does not grant you all these nice things, we would bring forward that's not our fault. That's then a flaw, a mistake in the system of your residence state tax system, not our problem. Complain at home, there you have the right to take part in elections, vote for parties who want to bring up a just and fair tax system in your home state. And indeed, we would not be responsible for that. So under that philosophy, we would say you have a taxable income of still 60,000, so you pay a tax of approximately 15,000 on that. like a single person. All your family is dead and gone in the tax file, because if you are a limited taxpayer, your tax claim is limited to the inland income, and evidently the view of the fiscal office is limited to you yourself. All your family never shows up in your tax situation. And now, surprise, in your state of residence, every income which you have is zero. Because under the double taxation treaty, the right to tax the German job income was given to Germany, and at home, that income is exempt from tax, and you have nothing more. So your home state income is zero, so you can deduct all your personal allowances from zero. So you have a tax saving effect at home, zero. So effectively, you can deduct them nowhere. And that was regarded as a kind of unfair and not really convincing. Under EU law, that presented a problem, because under the fundamental freedoms of EU law, it is forbidden to discriminate against EU citizens on grounds of their nationality. So if you are the citizen of an EU state, you can automatically claim full equal treatment with a German nationality taxpayer. If you are in a situation which is comparable with that of an inland citizen, and if there is no justification for making the differentiation. So a justification could mean that the EU treaties explicitly allow a discrimination by deviation from the general principle, or that there is a compelling reason which makes their different treatment necessary, and which is therefore respected by the jurisdiction of the European Court of Justice as something which is between the lines silently tolerated by the EU treaty, because they say we must interpret the treaties in a way that the treaties naturally did not want to extend the non-discrimination principle to an extent which brings down the breakdown of civilization and all legal rules in one of the member states. So legal rules which make a difference, which cannot be removed because otherwise a whole legal system would break down completely and everything would end up in chaos. That is silently tolerated by the EU legal rules. So what else follows from that? From the perspective of EU law, ladies and gentlemen, the differentiation between a taxpayer who has a residence in the inland and a taxpayer who lives abroad is seen as equivalent to the distinction on grounds of nationality. Now you could say, well, we don't discriminate according to their passports, only to where they live. But the EU legislation and the EU law is interpreted differently from classical public international law. International treaties usually are interpreted in a narrow sense. That means sovereignty is above all, and if a state did not explicitly promise something, then it's not promised. For example, if they did only promise not to discriminate on grounds of nationality, then residence or the nationality of the parents or the language you speak is still an allowed criterion. So the traditional principle of interpretation is, let's put it straight and simple. Everything which is said in an international treaty is usually, in case of a conflict, not meant seriously and honestly. You just stick to the words and not to the sense. Now, EU law is based on a basically and profoundly different assumption. EU law is assumed to have been meant seriously and honestly. And so, if you have to interpret a non-discrimination clause in EU law, the assumption is it's meant seriously. So, if we seriously promise not to discriminate Belgians, it cannot be tolerated to discriminate people because they live in Belgium. because, well, it's the natural fate of most Belgians that they live in Belgium. Well, you will also hit some Germans, 3 or 4, who also live in Belgium if you discriminate against people who live in Belgium. But if you honestly promise not to inflict a less favorable treatment on Belgians, it can't be allowed that you can distinguish between people who live in Germany and people who live in Belgium, because that's basically the same thing. So a covert or indirect discrimination on grounds of nationality is given if you distinguish on grounds of residence. Well, that can be tolerated from the perspective of EU law if it is a justified criterion, so if it makes sense, but not if it results in an unequal treatment in similar circumstances without any convincing reason, so if the differentiation is not necessary. So under EU law, if the situation else is comparable, an EU citizen always has a right to equal treatment with an unlimited taxpayer. You can only deny that if there is a difference in the circumstances or there is a justifying reason for the different treatment. And by the way, that is basically only one thing, because if there is absolutely no relevant difference in the situation, then you can't have a reason for drawing different conclusions and making different consequences. So overall, the overall question is then, do you have a difference in the situation which justifies different consequences? So in the case where you deny personal allowances for a limited taxpayer, you will have to ask for a compelling reason. The compelling reason is what we have already seen. You are able to deduct all these personal allowances in your home state already. So if you get them granted in the state of limited tax liability, that would be double deductibility of the same amount, and that's necessarily something which would bring along the breakdown of civilization in the field of tax law. Naturally, that would be an outrage, because you would spend 100 and probably in the end be able to save 120 in form of taxes or so. Not possible. But now you have to ask yourself if the compelling reason is really compelling. And now, if you have no income in your state of residence, as in my example before, well, there is no risk of double deduction of the same allowances. So you can't deny deductibility because there is no risk of the thing which you fear, of that misuse or abuse which you fear. The taxpayer in question has a claim to equal treatment, and you must bring forward a convincing argument. And it is never convincing to say, we must be strict with you because in other cases, not yours, there is a risk. Imagine you are allowed to shoot people who attack you in self-defense. Okay, but it's not possible to go into the street and say, I'm going to shoot down everybody who comes near me because there is a risk that others could attack me. So naturally, to restrict the rights of a person to a fair and good treatment, that can only be allowed if in the concrete case you have a compelling reason. So if somebody with a gun begins to attack you in the street, then there is a right to self-defense. If somebody just walks down the street, then to say I shoot him or her down because that person could have a gun, okay, I don't see one, but could have a gun and could be willing to attack me, okay, there is no concrete sign that that could happen, then this is simply murder. And the same logic applies to EU law. You can't bring forward that that person could deduct things twice if that person can prove that's not possible. Huh? So that was a reason why the European Court of Justice later ruled, or some years ago ruled, well, in such a case, you can't bring forward this as a compelling reason. The same thing is where the income situation of the person in question is absolutely comparable with that of an Indian taxpayer, who would get all these deductions in spite of the risk that there is a deductibility potentially given in another state. Indeed, it is the case that, for example, if you live in Germany as an unlimited tax liable person, you can deduct all your personal allowances, and nobody asks you if you have a second residence in another state and can deduct all that stuff in another state too. So if your income situation is absolutely comparable with that of an unlimited tax liable taxpayer, well, your whole worldwide income is taxed here, then that also justifies not to make any difference. So, because of that, the European Court of Justice held in the famous Schumacher case, that was the legal affair C279 from 1993, decided on the 14th of February 1995, that equal treatment has to be granted if the taxpayer has at least 90% of the worldwide income in the state of limited tax liability. Here, the old idea shows up that up to 10% deviation from 100% does not count. Or if the taxpayer has, outside the state of limited tax liability, less than the basic allowance. The basic allowance under German tax law is that amount which you need to survive and which is worked in the tax tariff. Now, if you only have the basic allowance to live, then you have no other income from which you could deduct additional personal allowances, like children's allowances. So it's clear if you only have the basic allowance outside Germany, there is no sufficient income outside Germany from which you could ever deduct a children's allowance, so you have a right to equal treatment. By the way, later, in one or two later cases, the European Court of Justice clarified or specified the jurisdiction in a way that if there is a personal deduction which you can claim here and which you cannot claim in your state of residence, and you cannot even claim a comparable deduction there, and it's clear that there is no comparable deduction there, then the double deduction argument does not convince, and then you have the right to equal treatment. Good. So in these two cases, equal treatment should have been granted. So that was the basic problem which forced our law to give equal treatment, and they did this by establishing an option to unlimited tax liability. The option is a good solution because a non-discrimination is a right to get a better treatment, but a non-discrimination, well, if you do not feel discriminated, so if you do not claim, if the basic or general treatment does not inflict negative consequences on you, then equal treatment is not necessary. Non-discrimination only is necessary if your treatment can be improved. So they said, we'll solve this by an option. If people feel they have a less favorable treatment, or if their overall situation leads to a less favorable treatment than under unlimited tax liability, they can opt into unlimited tax liability. And corresponding to the EStG's decision, they said, well, you can opt for German unlimited tax liability if you either have 90% or more of the worldwide income in Germany under limited tax liability, or if the income outside Germany is less than the basic allowance. And that was laid down in paragraph 1.3 of the EStG, an option for unlimited tax liability, which exists there. By the way, if you opt for that unlimited tax liability, that does not extend the German tax claims. You are still taxed only under that income which would already have been taxed under limited tax liability. Only the rules according to which that income will be taxed change. So basically the tariff changes and the personal allowances are granted, but the unlimited optional tax liability does not extend the German tax claims to the rest of your worldwide income, which would not be claimed under paragraph 49. Rather arbitrary now was that at that time when that option was introduced, Germany made the decision to distinguish between the basic option to unlimited tax liability under the 90% and the basic allowance rule. That was granted to everyone from everywhere, so also to people where EU law doesn't force us to give them that option, so to non-EU and non-EEA citizens. But then somebody came up with the idea, well, the splitting tariff, that really costs us money, and so we restrict that to the people where we are forced to grant it under EU law, so that can only be claimed by citizens of the EU and EEA who live within the territory of EU and EEA. That was rather strange because the 1.3 decision was led by the idea we can't treat people from other states unfairly, so we must treat them like EU citizens. They should get the same rights. And then next paragraph, paragraph 1a, if you want to opt also into joint assessment, then, oh no, you are not an EU citizen. We don't see any need to grant you equal treatment and non-discrimination. So that was contradictory in itself. But it is the present state of German legislation since 25 years. Well, okay. The Court of Justice later had very often the occasion to clarify and extend the jurisdiction on the personal allowances and equal treatment matter. So, for example, an option to unlimited tax liability must also be granted if the only income which the taxpayer has in the state of residence is tax-free due to other reasons. Because then in the state of residence you have no income from which you could deduct the personal allowances, and so the argument of double deductibility goes wrong or is a shot into the oven, as we in Germany would say, is a failure, and so the risk of double deduction is not given, so it can no longer serve as jurisdiction for denying equal treatment. Furthermore, many decisions where you can see similar details discussed happened in the last 25 years. For this, you should, under all circumstances, visit the homepage of the European Court of Justice. Here is the link, www.curia.eu. Search for things like income tax or personal allowances, or type in Schumacher, where then you might get all the decisions in which the Schumacher case is cited as a reference by the judges to why they decide in the concrete case in a similar way, or deviating from this, or really modifying this. The last interesting development, that was in 2017, when the court had to decide a case where somebody had no material income in the state of residence, but 60% in one state of source and 40% in the other state of source. So the state of source could not bring forward that it should have been the task of the state of residence to grant deductibility. But on the other hand, in the state of source, there was no 90% or basic allowance condition fulfilled. And here the court went back to the basic principle behind the original decision. They said the taxpayer has a right to equal treatment if you don't have a convincing reason and to deny that. And now the convincing reason usually is under international law principles. It is a task of the state of residence to grant these allowances. Well, that was not possible, so that was not an argument anymore. And now they could only say, well, there is a certain threat of double deductibility. Well, and in the concrete case, one could argue state C, the 40% state, does not grant any deductibility of personal allowances. Then they could only say, okay, if it comes to an obligation of the state of source, why should we grant all the personal allowances? Because if that would be established, then we would have a latent risk of double deductibility in the future. So what can we do? And here the court said, well, you have no reason not to grant at least 60% of all personal allowances if 60% of the worldwide income of the taxpayer comes from your state and there is no income in the state of residence. So this is rather the last interesting development here, has not yet been implanted into German national law, at least that I do not know that it could have been implanted in the meantime. But here you see that legislation evolves over time. Well, how did Germany transform the decisions in the course of time? I already mentioned that we have a 1-3 EStG option, which is granted to everybody who has 90% of the worldwide income in Germany or less than the basic allowance together in all other states of the world. Then you get the right to opt for unlimited tax liability with the intention that you then can claim all the personal allowances. But the great contradiction in itself was that equal treatment is only granted with regard to joint assessment to cases where the taxpayer is an EU or EEA citizen and also lives in EU or EEA. Evidently, the idea is if we deprive them of their rights because they are EU citizens and live in the US, then we don't deprive them of their rights to equal treatment because they are EU citizens. We deprive them of the rights because they live outside the EU and they felt entitled to do this. In my personal opinion, the treaty says every EU citizen has the right to equal treatment, so that should also apply to an EU citizen who lives in New York. But up to now, no decisions in that, or no cases in that constellation have gone up to court. Okay, now, yeah, there was a small break, so I have to find the point where I have to continue. Well, let me talk to you about that 90% condition. Germany made some rather peculiar interpretations of that 90% of the worldwide income rule, because they said for measuring if 90% of the income are subjected to German taxation, they only count that income which they can tax without any limit. So if you have dividend income from Germany, where a double taxation treaty says the maximum tax rate is 15%, they do not count that as inland income for the 90% rule. From my perspective, that makes no sense, at least in those cases where due to a loss carry forward or other things, you have a personal tax rate which is lower than 14% or 15%. Well, but that's in the law, so you would have to test it in court if it can be justified. And a further aspect is that under the present system of German income tax legislation, income from capital is no longer taxed as a part of your worldwide income, but is completely taxed separately. So in an inland case, income from capital, existing or not, has no impact on the taxation of your other six types of income. So it should not play any role for the determination of comparability. Now, the 90% rule measurements principles have been fixed or established in a time when that separation did not yet exist. So it should be clear that nowadays income from capital is to be seen separately and should therefore also play no role in the question if your situation concerning your worldwide income taxable under the six types of income in the EStG is completely identical or sufficiently comparable with the situation of an inland taxpayer. For that reason, in my personal opinion, there are good chances that a court would decide that income from capital should be completely left out of consideration when it comes to determining the 90% threshold or not. The administration has, as far as I believe, I'm not sure, a different view on that question, but I think that's not convincing. That's just to clarify this. Now let's have a look to some examples. Imagine you have two Belgian citizens, B1 and B2. They are married and live in Belgium, as many Belgians do. Then B1 has, in my example, a job in Germany with 45,000. B1 also has a rental income from a house in Belgium, 10,000, and B2 has income from a job in Germany, 30,000. Now let's talk about options. B1 has less than 90% of the worldwide income from Germany, and the basic allowance is also exceeded because the basic allowance now in 2021, this is today when I record the video, that basic income is 9.5 and he or she has 10,000 in Belgium, so more. So an option as a single person is not possible. Now, B2 would fulfill the 90% test in Germany, could opt, and B1 and B2 as a married couple could opt under paragraph 1a because if they opt for joint assessment, the 90% of the worldwide income rule will be tested with regard to their added income, so the total of their two incomes. And indeed, 90% of the total income of both spouses comes from Germany. And you could also test the other condition. One of them is sufficient, if they have outside Germany less than the basic allowance, in case of a married couple, less than two basic allowances, then they also can opt for joint assessment. Both would be possible here, so they can opt for joint assessment. Example 2, B1 and A2 are Belgian and Austrians. They are married and live in Belgium. Now, B1 has a job in Germany, 60,000. A2 has a job in Belgium, 40,000. Now, is an option possible under 1.3? And the answer is under 1.3, B1 can opt because B1 has 100% of his or her worldwide income from Germany, so option is possible as a single person. The married couple option would require that 90% of the worldwide income of the couple together comes from Germany. That is not the case, only 60%. And that they do not have, as a married couple, more than twice the basic allowance outside of Germany. Basic allowance is approximately 9.5, taken times 2 would be 19,000. Now they have 40,000 coming from Belgium, so second condition also violated. No option is possible. So the only thing which is possible here is B1 can be treated under unlimited tax liability rules in Germany, but there will be no joint assessment. Example 3. Let's turn to France. F1 is a French citizen and lives in the German inland. Now is married to F2, and she or he, however the constellation may be, lives in Paris, France. F1, in addition to the German residence, still shares the residence in Paris, so they do not live in separation. That is why I tell you this. F1 has 90% income from Germany, and F2 is jobless or is only taking care of the children, or what else? No? Or is an author and has only been writing a book but has no income at present. Whatever, it doesn't count. F1 can opt under 1.3 because 90% of F1's income comes from Germany, even 100%. Now, F2 and F1 as a married couple also can opt because they also pass the 90% test. And what I should bring to your memory again is naturally that F1 and F2 can only make use of paragraph 1a, the option for joint assessment, because they are citizens of an EU state and live in the territory of the EU or the EEA. Yeah. Well, another example. F1 and F2 are married and live in France. F1 earns 90,000 in Germany. F2 has 9,000 income either from letting a house for rent in France, or from a share in a business in France, or something else which can only be taxed in France. Now, the solution of the situation here is that F1 can opt under 1.3 EStG as a single person for unlimited tax liability because 100% of the taxable income comes from Germany. F1 can also opt for joint assessment under 1a EStG because F1 is a citizen of an EU state, lives in the EU, and has more than 90% of the worldwide income of the couple from Germany. In case of joint assessment, F1 and F2 would be taxed in Germany on the basis of the average of their total taxable income, so 90,000 divided by 2. The tax-free income would, under certain circumstances, be taken into account for the determination of the tax rate, so for the proviso safeguarding progression. So for the tax rate, if the proviso applies, one would calculate 99,000 is the total worldwide income they have, divided by 2 is 49,500, which would be relevant for the calculation of their percentage, which they have to pay as a tax rate. Now let's leave the EU and let's go to Switzerland. We have now a Swiss citizen who has taken a job up in Germany. 60,000, because 60,000 is such a nice figure. One needs to have some dreams still, and this video shall also be realistic in 20 years still. So that's with a view to inflation, dream of 60,000. The spouse of that Swiss citizen is S2, also Swiss. S2 has income from a job in Switzerland, 18,000 only. Now, the solution. S1 can opt for unlimited tax liability as a single person under 1.3 EStG because that rule does not ask for nationality, and S1 fulfills the 90% test. Simple. Under 1a, so the joint assessment option, S1 is not eligible for that option to joint assessment because S1 as a Swiss citizen is not covered by that rule. It only applies to citizens from the EU or an EEA state, but from no other nationality. Now, this is not yet the full truth. There is a treaty between the EU and Switzerland from 1999. It's on the freedom of movement of persons with regard to freedom of establishment granted for natural persons and freedom of workers. So Swiss citizens have under that treaty a right to take up a job everywhere in the EU or to use the freedom of establishment everywhere in the EU if they are natural persons. And now this rule has to be interpreted, that's clear from the whole framework of the treaty, in an exact parallel way to the freedom of establishment, freedom of workers in the EU treaty. So there is also a non-discrimination rule combined with these two freedoms in the Swiss treaty. So we have now a Swiss citizen who has taken up a job in Germany. So that Swiss citizen has made use of that right granted under the treaty. That entails non-discrimination for that Swiss citizen, and it's in the EU rule, so it has to be interpreted effectively. So you can't discriminate as one on the grounds of nationality and not on the grounds of any other criterion, for example, residence, which ends up with the same result. And now, as the German law says, paragraph 1a says, if you fulfill 90% of the married couple is taxed under German law, then if you live in the EU or in the EEA and have the right nationality, you can opt for joint assessment. Then it would clearly be a discrimination to deny that option to a Swiss married couple because they are Swiss and live in Switzerland, which is natural for Swiss people. So they have, under the EU-Swiss Treaty from 1999, a right to equal treatment, so they can opt for a joint assessment. The only difference is there is a different legal basis for that. It's no longer paragraph 1a EStG, it's paragraph 1a EStG in combination with the EU-Switzerland Treaty non-discrimination principle. Now let's go further a bit. Let's have a look to people from somewhere completely else. A Tunisian citizen, and I believe I wrote Tunisia wrongly in the English language, but I hope that does not really bring along a shitstorm in the comments. If you want to complain, do it. It was a genuine mistake, and just live with that. Tunisian. A citizen lives with her husband in Belgium, and she gets 90% of her income in Germany. Must have been a bad day today. The husband is jobless and without income at the moment. Now, option possibilities first. The Tunisian citizen herself can opt for unlimited tax liability as a single person because 1.3 does not ask for citizenship questions, so she can opt. Now, can she also opt for joint assessment? And the answer under 1a is no, it's not possible for a Tunisian citizen because the couple has more than 90% of the worldwide income from Germany under German tax jurisdiction. No dividends, no interest, and so included, to simplify matters. They do live in an EU state, but they are not nationals of an EU or EEA state. So 1a cannot fully be fulfilled, so it cannot apply to them. But again, the truth is a bit wider. There's more than this, which makes up the truth, because there is also a double taxation treaty of Germany with Tunisia, and that has an anti-discrimination clause, which resembles Article 24 of the OECD Model Convention. The following one is my own personal translation. The German text can be looked up in the internet under www.bundesfinanzministerium.de. There you can find it, and in every good database. Citizens of a contracting state may not be subjected to any taxation or any obligation connected with taxation, which is different or more burdensome than the taxation and the obligations connected with taxation to which citizens of the other state are subjected under same conditions, especially with regard to their residence, are subjected or can be subjected. Sentence number 2 clarifies that although Article 1 says this treaty applies to residents of the two states, This non-discrimination on grounds of citizenship clause also applies to every Tunisian, also to those Tunisians living not in Tunisia and not in Germany, but in the rest of the world. So this non-discrimination clause is applied irrespective of the applicability of the treaty to the concrete tax case. It just applies to every income taxation of a Tunisian everywhere in the world with regard to German law. Now, as this is a clear legal order, let's test again the situation. We have a Tunisian taxpayer who resides in Belgium, so in an EU state, has 90% of the worldwide income of the married couple taxed in Germany, and so fulfills all conditions of 1A but one. That is the citizenship condition. So in this case, only the nationality deprives that Tunisian taxpayer of the right to joint assessment. And now Article 24 of the DTT says we supply or we replace that condition by the right to equal treatment. You fulfill everything. The only difference is your nationality, and on grounds of nationality only, there is no negative treatment possible. So Article 24 here gives an immediate right to equal treatment with a Belgian in Belgium and fulfilling 1A. So our Tunisian taxpayer now has the right to opt for joint assessment under Article 24 in combination with 1A. Not under 1A, but under Article 24 in combination with 1A. So the idea that 1A application is limited to EU and EEA citizens is only half of the truth, because indirectly its applicability, its scope of application is extended. If we have now a different constellation, a Tunisian taxpayer living in Tunisia, getting 90% of the worldwide income from Germany, being married, spouse has no income, the spouse refrained from having an income just to simplify our lives, because it would be more complicated if the spouse had an income, but it would not make really a difference. It just makes it easier to explain. Now the legal situation is that Tunisian taxpayer can again opt as a single person for unlimited tax liability. That's undisputed. 1.3 EStG does not ask for nationality questions. 1A EStG cannot be fulfilled because the Tunisian taxpayer does neither live in a state of the EU or EEA, nor has the correct citizenship of one of these states. Now let's test again the non-discrimination clause of Article 24. It does not help now, because the DTT is a classical, traditional, international law matter, which means it has to be interpreted in a narrow sense. What has not been promised explicitly is not promised. The only thing promised was we do not discriminate on the grounds of citizenship. Now, citizenship it is well known that citizenship is not the same as residence or anything else. The treaty clause even says are the same conditions, for example, same conditions with regard to residence. So here we have the wrong citizenship, but something else is also wrong with 1A, the wrong place where they live. Here our Tunisian taxpayer does not live in an EU or EEA state, but in Tunisia. And so we have two differences, citizenship and the place where they reside. And that's one difference too much. Article 24 gives you a right to equal treatment if only your citizenship makes a difference. Now, this is not the case here. You would have to fill up the gap with another non-discrimination clause, and this is not in Article 24. Now, surprise, there might be, in certain cases, still treaties of association between the EU and some Mediterranean countries from the 1970s or so. Later, they have been reworked and modernized, and sometimes I don't know because I didn't find or look for the Tunisian treaty. So this is now rather an abstract thought. Sometimes there are treaties with between the EU and Tunisia which say, first, the workers from your country do not have the right to enter the labor market of a member state. But if a member state grants one of your citizens access to the labor market in its territory, then they have to grant non-discrimination for this person. So it might be that there is in an old or current treaty a kind of a non-discrimination clause under EU law. And now, if we had a Tunisian taxpayer or a taxpayer from another country where such a clause still exists, and the income that would have to be a further assumption, comes from an activity which was making use of these rights, then the Tunisian taxpayer would have a right to non-discrimination under EU law, and that would be a clause which would have to be interpreted effectively and not narrowly, not in a narrow sense. EU law is always meant seriously and honestly. So if there is a non-discrimination clause, it would also include the fact that Tunisians may not be discriminated on the grounds that Tunisians sometimes live in Tunisia. So, or move back to Tunisia after, for example, they worked 30 years in Germany and then decided to spend their pension in Tunisia. So discriminating them on the grounds of that would be forbidden under EU law. In case where that was not the case, so where you don't have such a non-discrimination clause in such a treaty, you could still check if there is another legal basis in EU law which you could bring forward. For example, if it's income from capital, you could think about in the freedom of capital, which is granted also to people from third countries with respect to capital investments in the EU. There might also be promising to have a look into the Charter of Fundamental Rights of the EU if they also grant certain human rights or non-discrimination rights to people of third countries or people from third countries who have been permitted to reside in the EU, or there might be many things. So the basic message which I want to bring forward here is when you have clauses like these in 1A, you must have the right citizenship and live in the right place. It might also be that in combination with additional legal rules, you might end up in the applicability of something like the contents of 1A in other cases too. For example, it might be in some strange constellations that somebody living in Tunisia, Morocco, Egypt, USA, or where else might have a claim to equal treatment. So to sum up, the option for unlimited tax liability is usually used in order to obtain the deductibility of the personal allowances. The really great thing, which brings the bulk of the money which you can save, is that you can opt for joint assessment. For that, you must be married. By the way, that's another question. Are you married from the perspective of German civil law? So you must have concluded a valid marriage under some law somewhere in the world, which is accepted as valid under the rules of German civil law. That's not always easy. There might be some problems. But if you are a married couple, then you can opt for joint assessment. If you are a citizen of the EU and EEA only, as far as laid out in 1A, But this is only half of the truth, because there are sometimes non-discrimination rules in other legal sources, which then make it possible that, yeah, that in the end you also can claim joint assessment. And I bet, I can nearly guarantee that in practice, very often, because 1A only mentions the EU citizens and EEA citizens, that in many, many cases people will overlook these other claims to non-discrimination, so that perhaps the one or other case in reality goes wrong, where people don't notice that they also have a right to non-discrimination and to joint assessment. So that should be kept in mind. Well, another last question is naturally, how is personal tax liability dealt with apart from German law, so in EU law, multilateral instruments under the BEPS project and so on. And the basic message here should be that there is no rule on personal tax liability in the multilateral instrument, which makes sense. Personal tax liability is not about the right to tax income or not. It's just how you exercise that right to tax. And multilateral instrument is something which changes the DTT contents. The DTT only says which state can tax which income, but the rules how it is taxed, that's always a matter of that state itself. That's never dealt with in the DTT. And so it's clear that you will have no rules on options or not about personal tax liability in the multilateral instrument. The BEPS project also, well, with personal allowances, no tax saving models can really be run for multinational enterprises, and that is rather the focus of the BEPS project. And the BEPS project also talks about taxation rights and how you tax the big ones, the big players, the global players, multinational groups, and so. So naturally, you will have no rules in the BEPS project, which you could expect there. No rules are also on personal tax liability in the Anti-Tax Avoidance Directive of the EU for two reasons. Because first, the Anti-Tax Avoidance Directive of the EU deals with corporation tax only, and there you have no question of personal tax liability and personal allowances. Huh? So no problem about that. The only thing which you could debate concerning personal tax liability in general, that would be to whom do you apply worldwide income taxation, so that you should usually apply it to people living in your country or juridical persons who are rooted in your country, who have seat or place of management there. And there has been, in the context of the financial crisis 2008, and perhaps a bit to the left or right of the BEPS project, some political pressure that states like Ireland, who did not tax under unlimited tax liability corporations with only the statutory seat but not the place of management in Ireland, that they changed their approach and also tax all companies which are registered in their country with official address. So that should be sufficient for this topic today. Thank you for your listening to this little video, if you listened. Thank you for just sleeping all the time silently if you fell asleep. If so, wake up again. And at least it's a good thing that you evidently survived this video. I would be pleased to see you again when the next video comes. And until then, enjoy the break and have a good week, rest of the week, holiday, or whatever is true for you at the moment when you see or have seen this video. Thank you very much. Till the next time.